A significant Supreme Court case is scheduled for oral arguments on October 15th, and it could fundamentally reshape your constitutional rights regarding police entering your home without a warrant. This case builds on a previous unanimous Supreme Court decision that addressed warrantless searches and firearms seizures inside private residences. Hit that subscribe button to stay updated on this developing story and other critical legal issues affecting your rights. Recently, the Trump administration received approval to participate in the oral arguments for this case, making it even more consequential. Let's break down what's at stake. The case heading to the Supreme Court is Case v. Montana, and it centers on the question of when law enforcement can legally enter someone's home without obtaining a warrant. This challenge attempts to extend the protections established in a prior 9-0 Supreme Court ruling that dealt with warrantless searches and seizures of firearms. With oral arguments set for October 15th and the Trump administration now joining the proceedings, this case has taken on heightened importance for everyone concerned about Fourth Amendment protections. The events leading to this lawsuit began when Trevor Case's ex-girlfriend contacted police with alarming claims. She reported that Mr. Case had threatened to harm himself and possibly law enforcement officers if they responded to the scene. She also mentioned that he might have a firearm. Several of the responding officers had previous encounters with Mr. Case and were aware of his history involving mental health concerns. 4 police officers arrived at Mr. Case's residence and began assessing the situation from outside. They peered through open windows, shined flashlights into the home, and called out to Mr. Case, but received no response. One officer reported seeing what appeared to be an empty handgun in a holster and a notepad inside. Despite knocking on the front door and announcing their presence, Mr. Case did not answer. The officers discovered that the front door was unlocked. After spending approximately 40 minutes outside the residence, the officers made the decision to enter through the unlocked door. Before doing so, several officers expressed serious concerns about entering the home, given their prior interactions with Mr. Case and the ex-girlfriend's warnings about him being armed and potentially hostile toward police. There was brief discussion among the officers about alternative approaches, calling Mr. Case's father to come to the residence, having the father attempt to reach him by phone, or trying to contact Mr. Case directly on his cell phone. Ultimately, the officers decided against these alternatives. Instead, they retrieved ballistic shields and rifles before entering the home. Once inside, 2 officers proceeded upstairs. One officer entered an upstairs bedroom where he observed what he believed was a closet curtain suddenly jerking open, revealing Mr. Case's face. The officer then saw what he interpreted as a black object that he believed was a handgun. Reacting to this perceived threat, the officer fired twice, striking Mr. Case once in the arm and once in the stomach. Mr. Case survived after receiving medical treatment. A subsequent search of the home uncovered a handgun in a laundry basket located in the same bedroom. Mr. Case argued that the officer's warrantless entry into his home violated his Fourth Amendment rights. Therefore, he contended, the handgun and any other evidence discovered in his home should be suppressed and inadmissible in court. The lower courts rejected these arguments, and the case eventually reached the Montana Supreme Court, which sided with the state in a narrow 4-3 decision. However, Mr. Case appealed to the United States Supreme Court, which agreed to hear the case. The core legal question before the Supreme Court is this: can law enforcement enter a home without a search warrant based on less than probable cause that an emergency is occurring? Or does the emergency aid exception require probable cause? In his petition to the Supreme Court, Mr. Case argues that while the court has recognized limited exceptions to the warrant requirement for exigent circumstances, it has jealously and carefully drawn those exceptions. He urges the court to apply the same strict approach when defining the emergency aid exception, requiring officials to have probable cause to believe an emergency existed before conducting a warrantless home entry. Central to Mr. Case's argument is the Supreme Court's decision in Caniglia v. Strom, which rejected any freestanding community caretaking exception to the warrant requirement. However, the Montana Supreme Court upheld the officer's warrantless entry into Mr. Case's home based on a community caretaking rationale, using a test that required only reasonable suspicion of an emergency, a lower standard than probable cause. The Caniglia versus Strom case involved a married couple who had an argument during which the husband placed a goon on the table and told his wife, "Why don't you just take it and put me out of my misery?" His wife left the home and spent the night at a hotel. The next morning, when she couldn't reach her husband by phone, she called the police. Officers and the wife arrived at the home to find Mr. Caniglia on the front porch, apparently fine. Nevertheless, the officers remained concerned and decided to take him to the hospital for a psychiatric evaluation. During conversations with the officers, Mr. Caniglia explicitly stated that he did not consent to them taking his firearms. He was clear that he did not want them to seize his guns. After Mr. Caniglia left for the psychiatric evaluation, the officers approached his wife and falsely told her that Mr. Caniglia had consented to them taking his firearms. Based on this lie, she allowed them into the home, and they seized the guns. This case reached the Supreme Court in 2021, resulting in a rare 9-0 unanimous decision in favor of Mr. Caniglia. The Supreme Court struck down the community caretaking rationale that had been used to justify entering the home and seizing the firearms. Since that ruling, the Supreme Court has not revisited the circumstances under which police may enter a home under emergency exceptions. That makes this upcoming case particularly significant. It represents the court's first opportunity since 2021 to potentially expand on Caniglia and further clarify Fourth Amendment protections against warrantless home entries. The Trump administration has filed an amicus brief supporting the state of Montana and advocating for a reasonableness test. In their brief, they argue that the Fourth Amendment's standard is reasonableness, not probable cause in all circumstances. They contend that probable cause applies specifically to warrants, not to every search or seizure. Since emergency aid entries occur without warrants, they argue, the only requirement should be that these entries are reasonable under the circumstances. Essentially, the Trump Department of Justice is pushing for a lower reasonableness standard for emergency aid situations, rather than requiring probable cause. After filing their amicus brief, the Trump administration requested permission to participate in the oral arguments in support of Montana. In their request, they noted that the United States has previously presented oral arguments as amicus curiae in cases concerning the interpretation and application of the Fourth Amendment, including in cases involving emergency aid. They cited Lang v. California, Barnes v. Felix, and Caniglia v. Strom, all cases that have dealt with similar Fourth Amendment issues. The administration stated that participation by the United States in oral argument in this case would be of material assistance to the court. The Supreme Court granted the Trump administration's request. This means the state of Montana will have the support of the Trump DOJ during oral arguments, as they advocate for the reasonableness standard over the probable cause requirement. The court now has the opportunity to clarify or expand upon the unanimous Caniglia ruling and other Fourth Amendment cases. The decision in Case v. Montana could have significant downstream implications for the constitutional protections all Americans have against law enforcement and federal government entries into their homes under warrant exceptions. This case will help define when officers don't need a warrant to search, seize, and conduct these types of activities. Oral arguments are scheduled for October 15th, and this is a case worth watching closely. It will be particularly interesting to see how the Trump DOJ argues its position during oral arguments. While we have a good idea of their general stance from the amicus brief, seeing how they present their arguments and respond to the Supreme Court's questions will be revealing. Equally important will be the questions the Supreme Court poses not just to Montana's legal team, but also to the Trump DOJ. This is where things stand right now with this critical warrantless search and seizure challenge before the Supreme Court. As more information develops and as we approach the oral arguments, I'll keep you updated on any new developments. If you found this analysis helpful and want to support the channel, one of the best ways to do that is to subscribe. Thank you for your support, and I'll see you in the next one.